pre-incorporation agreement. The term pre-incorporation agreement, as I suggested you, is very important because these are the soul and heart of the company formation process. As I told you that here the corporation, that is a contemplation in the eye of law, that is a legal device, that is a legal person speaking, so that is a corporation aggregate also. So in this corporation aggregate we find that certain individuals are given a corporate cover and they are held as a different individual or different personality, that is a corporate personality, and corporate personality is altogether different from the other members who are actually the subscribers of the company. So the actual position is that they are doing the thing for a company which is going to come in future. So whatever acts they are doing now, that will be validated only when the company gets incorporated. Meaning thereby whatever agreements they have to sign in order to mobilize the resources for formation of the company, that has to be done in some representative character, wherein they are disclosing that whatever material, whatever resources they are getting, that would be utilized for the formation of the company. Meaning thereby whatever agreement they are signing, that should be signed on account of or on behalf of a company which is going to come in future. So this agreement, which basically is very pivotal in company formation process, is known as pre-incorporation agreement. But the legal issue with the pre-incorporation agreement is that those agreements are signed by the company which is not in existence, and those agreements will be nullity in the eye of law, as explained in a case Kellner versus Baxter, and that Kellner versus Baxter case is a fine example about the crucial issue that was involved in the pre-incorporation agreement, wherein two people, Kellner and Baxter, they incorporated a company, promoted a company, Grapes and Royal Alexandra Hotel Company, and therein the one party tried to sell the wine to the other party. The price was £900, and this was done by a sale agreement which was signed on January 27, 1866, when the company was not incorporated. The directors, the would-be directors of the company, ratified the agreement on February 1st, 1866. Even now the company is not incorporated. Then it was finally the company finally received a certificate of incorporation on 20th February, and subsequently also directors signed a ratification agreement on 11th April. So we see that there is a sale happening of wine which will be used for business by the company which is going to come, and the sale agreement is actually taking place much before the date of incorporation, and date of incorporation is very important in this regard because after that only the legal existence of the company will come. So in this case the court held that until the company is incorporated it cannot contract, and because it cannot contract, then the effect of contract will be nullity because the company was not there, being an honest. There was no existence of the company. That's why pre-incorporation agreement will not be valid, and all those things which are being mobilized, the liability for that will be held, or liability for that will be borne by the promoters. So because of this technical issue regarding the pre-incorporation agreement, there was a kind of repelling factor which stops the promoters promoting a company, because they may be in a situations that company may avoid all those agreements subsequently to the incorporation process, because as I told you in the first AGM, the promoters are made accountable that whatever pre-incorporation agreements they have signed, that would be checked and verified. That's why the Jenkins Committee in 1962 in England recommended for that we should have a provision for the protection of the promoters, and therein by the recommendations of Jenkins Committee, there was an amendment made in the English Companies Act 1985 under section 36, wherein the promoters were given a relief, and the relief was that if the pre-incorporation agreements is warranted by the terms of incorporations, then the company cannot repudiate its liability, the company cannot reject all those agreements. And then in the line of that, we are also a common law country, we also had an amendment in our act, and the amendment was made in the Indian Specific Relief Act 1963 in the provision 15H and 19E. In both situations, if there are pre-incorporation agreements, then in pre-incorporation agreements they can be made enforceable by company or against company if the activity which is the part or subject matter of the pre-incorporation agreement is warranted by the terms of incorporation. Warranted by the terms of incorporation is a very wide term. That basically means that whatever thing, whatever services, whatever activities has been done in the name of pre-incorporation agreement that is within the term of incorporation or not depends upon the situations. Like as I told you that if a company is being formed, then promoters may have so many other opportunities. But if those opportunities are being availed by the promoters for their vested interest, then the company can obviously avoid it, holding it ultra vires, meaning thereby that was not warranted by the terms of incorporations. Like having a holiday while promoting a company when he is going to sign a technical or technology transfer agreement with some other country can be a situations which will be not warranted by the terms of incorporation. So this is the situations regarding the pre-incorporation agreement.